United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone. We're happy to be with you and happy to have you here today. And we welcome you to this December 2025 session of the Tennessee Supreme Court here at Bryan College as a part of our court Scales project. Scales, which stands for the Supreme Court Advancing Legal Education for Students, brings together judges, attorneys, and students to develop a better understanding of and a more transparent look at the judicial branch of government and the role of the courts in our society. Unlike cases you see on TV, today you will hear real cases with real lawyers representing real clients and real judges deciding the issues. We appreciate your participation and we hope you enjoy the case you will hear today. I want to thank Bryan College and Dr. Douglas Mann, the president of the college, for having us here today. We would also like to recognize and thank the Tennessee Highway Patrol, the Ray County Sheriff's Department, and Bryan College Security for assisting with security during this event. We also greatly appreciate the efforts of our staff at the Administrative Office of the Courts and the staff of the Appellate Court Clerk's Office for making this project happen and the success that it is. Thank you as well to the attorneys who are arguing their cases here today for the extra time and effort required for the participation, including allowing the students to ask questions of the attorneys after the arguments today. We hope all of you will stay engaged with the judicial branch after court today. You can follow us on Twitter at TNCourts, on our website at tncourts.gov, and on Facebook. The opinions we write on today's cases will be posted to our website and to our Twitter feed. Now I'd like to take a few moments to introduce you to the justices of the Tennessee Supreme Court. I'll introduce them according to their length of service on this court. First, and to my immediate right, is Justice Holly Kirby. Justice Kirby graduated from the University of Memphis with a degree in engineering and from the University of Memphis School of Law. She clerked for a federal judge on the Sixth Circuit Court of Appeals and then practiced law in Memphis for a number of years. She served on the Tennessee Court of Appeals, one of our two intermediate appellate courts, for 19 years before being appointed to the Supreme Court in 2024. She began her service in 2024 and she serves as the Chief Justice of this court from September 2023 through August of 2025. Justice Kirby lives in Memphis. Next is Justice Sarah Campbell to my immediate left. She earned her bachelor's degree from the University of Tennessee in Knoxville, a master's degree from Duke University, and her law degree from the Duke University School of Law. Justice Campbell served as a law clerk for a judge on the 11th Circuit Court of Appeals and later served as a law clerk to Justice Samuel Alito on the United States Supreme Court. She also practiced law in the D.C. area for a period of time. Prior to her appointment to the Tennessee Supreme Court, she was Associate Solicitor General and Special Assistant to the Attorney General in the Tennessee Attorney General's office. Justice Campbell began her service on this court in 2022. Justice Campbell lives in Nashville. Next is Justice Dwight Tarwater, who is joining us by Zoom today, as you can see to my far right. Justice Tarwater earned his BA degree and his law degree from the University of Tennessee, Knoxville. He served as a law clerk to a judge on the Tennessee Court of Appeals. Justice Tarwater practiced law in Knoxville for many years, specializing in complex litigation at both the trial and appellate levels. He served as general counsel to former Governor Bill Haslam from 2014 to 2019. Justice Tarwater began his service on this court in 2023 and lives in Knoxville. As we talked about and as obvious, Justice Tarwater was not able to join us in person here today, and he is joining us by Zoom, but he wanted to say a few words to you, the students, since he was not able to be here in person. Justice Tarwater?
Thank you, Chief Justice Bivens, and ladies and gentlemen. My apologies that I'm not seated next to my colleagues. I'd like to thank them for the grace to be able to do this, and I would like to tell the students that I'm very sorry that I won't be able to have lunch with you all and interact with you about these cases. But one thing that is educational in and of itself is the fact that we can do this way. 10 years ago, I would not have been able to participate remotely. So you all study very hard in your technology classes because it is a very important thing to be able to do in this day and time. And to the lawyers, don't worry, I've read everything and I'm ready for you. Thank you, Chief Justice.
Thank you, Justice Starwater. To my far left is Justice Mary Wagner. Justice Wagner received her undergraduate degree from the University of Colorado and her law degree from the University of Memphis College of Law. She clerked for a judge on the Tennessee Court of Appeals and then practiced law in Memphis for a number of years. Beginning in 2016, Justice Wagner served as a circuit court judge for the 30th Judicial District in Shelby County. She began her service on this court in 2024. Justice Wagner lives in Shelby County. I'm Chief Justice Jeff Bivens. I received my undergraduate degree from East Tennessee State University in Johnson City and my law degree from Vanderbilt University School of Law. I practiced law in Nashville for a number of years and also have served as Assistant Commissioner and General Counsel for the Tennessee Department of Personnel. I served as a trial court judge in the 21st Judicial District, which at that time was comprised of Hickman, Lewis, Perry, and Williamson counties. I then served as a judge on the Tennessee Court of Criminal Appeals. I began my service on this court in 2014. I live in Williamson County. As you can see, we're from different parts of Tennessee, have different backgrounds, and went to different law schools. But together, we all consider it a great privilege to serve on the highest court of this state. And we are committed to upholding both the United States and the Tennessee Constitutions, to protecting individual rights, and to applying the laws of this state equally and without favoritism. And we are now ready to begin hearing the case that we have this morning. I will ask Mr. Jim Hivner, our appellate court clerk, to now call the case for this session.
Danielle Lowe, ex-rel. Beau Christopher Lowe et al. Versus Bridgestone America's Tire Operations, LLC.
As counsel is coming forward, I would remind everyone that each side has 30 minutes for their argument. If the appellant wishes to reserve any time for a rebuttal argument, please do so at the beginning of your argument. Counsel?
Thank you, Chief Justice Bivens. I'm Isaac Sanders. I represent Bridgestone America's Tire Operations, LLC. I would like to reserve 6 minutes for rebuttal, please.
Thank you.
This case involves a fatal accident that occurred at Bridgestone's tire manufacturing plant in Warren County, Tennessee. The deceased, Beau Christopher Lowe, was an employee of Cumberland Machine Company, which is an independent contractor of Bridgestone. Cumberland contracted with Bridgestone to perform certain services around the plant, which included equipment maintenance and repair services, which is the type of work that Mr. Lowe was performing on a heavy piece of equipment called a tire mold plate when the accident occurred. The plate fell and ultimately landed on Mr. Lowe. He died from the resulting injuries. This case involves a tragedy in every sense of the word. Mr. Lowe had many friends who felt his loss, including many at Bridgestone. That fact is not lost on Bridgestone, the company, and it's not lost on me as I stand here before this court asking this court to end this lawsuit on multiple grounds. I will describe the facts in greater detail shortly, but first I will briefly summarize the issues before the court. The plaintiffs, who are Mr. Lowe's family members, filed this lawsuit seeking to hold Bridgestone liable in tort under a premises liability for Mr. Lowe's injuries and death. On 4 independent grounds, that claim, the premises liability claim, is barred as a matter of law. 3 of those grounds relate to Tennessee's workers' compensation exclusivity rule found at Tennessee Code Annotated 50-6-108, and the standard for applying that rule that this court adopted in Lindsay v. Trinity Communications, Inc. The 4th ground that Bridgestone has moved for summary judgment on relates to the exception to the general rule that landowners owe a general duty of care to independent contractors to provide a reasonably safe place to work. The exception that we're traveling on was identified in this court's opinion in Blair v. Campbell. This is a case where there is a statutory scheme and court-created guidelines that dictate the end result. We are here before this court because the decision by the Court of Appeals addressing these issues conflicts with established law in multiple respects. The decision creates uncertainty for businesses and potential claimants alike with respect to both areas of the law that are at issue. Unless your honors direct otherwise, I will start with Bridgestone's exclusivity rule defense before discussing the Blair or exception, or what is also referred to as the independent contractor exception. Tennessee's workers' compensation law extends coverage to statutory employers, which, although not the direct employer, are secondarily liable for workers' compensation benefits. And this rule was intended to expand coverage, to provide an additional layer of protection for workers in this state, and that's what it does. The legislature also saw fit to create a corollary to this rule, which is the exclusivity rule found in Section 50-6-108, which provides that all other rights and remedies that might have otherwise been available to that principal, to the company that is secondarily liable is excluded. And in Lindsay, this court identified the four circumstances in which a company will be deemed to be the statutory employer. If any of the four circumstances are present, then the company is a principal contractor or statutory employer, and the exclusive remedy rule applies. 3 of those circumstances were present in this case. The work that Mr. Lowe and Cumberland were performing were part of the regular business of Bridgestone. Second, the particular task that Mr. Lowe was performing at the time of this accident was the same type of work performed by Bridgestone employees every single day. Indeed, it was the exact same task that Bridgestone employees regularly perform.
Was it really? I want to probe that a little bit. Bridgestone employees were doing some cleaning of the molds, but wasn't Mr. Lowe doing a different level kind of work?
Mr. Lowe, the answer is yes, Your Honor. And both things can be true at times. So the way that this is set up, and I'm glad we're starting here because this is where I intend to focus, to borrow from Justice Campbell's question earlier, we believe that the cleanest path and the appropriate path for resolving this case is under the regular business test and under the same type of work test. And we believe that both of these standards are clear and that the facts clearly support Bridgestone's position in both instances. So with respect to the type of work that Mr. Lowe was performing, that particular prong, the or in the third circumstance that's identified in the Lindsay case, focuses on the particular task that he was performing. It is undisputed that in this situation, every tire mold plate is part of a tire mold, which is where you cure the tires. Those pieces of equipment have to be maintained within the plant for various reasons, which I'll discuss when we talk about the other test. But the particular task that Mr. Lowe was performing at the time of the accident was he was using a drill with a tiny little drill bit to drill out the vent holes in the mold plate. So when a tire is pressed against the mold plate in the pressure cooker, essentially, it presses against it and pushes pieces of little rubber out, which is why you get those hairs on a brand new tire that you see. Those have to be cleaned out periodically. And so what Bridgestone does is, in the mold repair area within which the mold repair shop where Mr. Lowe was working is located, Bridgestone has a blasting machine that they put every piece of equipment through to essentially do the first round of cleaning and removal of the debris and buildup. Then after that, there's a conveyor belt, and Bridgestone employees then drill out the vent holes themselves in every one of these tire molds. And then after that work is done, there's a mechanical cleaning process, there's a manual cleaning process by Bridgestone that includes this vent hole drilling. A Bridgestone worker then inspects the mold, and some portion of those molds will have a greater defect. It can be, and in this context, it's all considered mold repair within the industry. That's why they call it the mold repair area, even though a lot of this is what we would all, as lay people, consider to just be a type of cleaning. This particular task, vent hole drilling, plaintiffs have taken a hard stance on this for a number of reasons, that this is in fact repair work. Well, Bridgestone employees do that exact same task right next door to where Bridgestone does it.
Here's what I'm getting at. The Lindsay case specifically describes the type of work as a fact-specific inquiry. You're talking about a lot of very detailed facts. I'm not sure that the work Mr. Lowe was doing is interchangeable with the work that regular Bridgestone employees were doing. That strikes me as significant and points to the larger issue of we can't, in a fact-specific inquiry, we can't do a lot of arm waving and say, oh, it's just all falls under the umbrella of X. I really wonder if the facts are sufficient for us to make a legal determination that this was the same kind of work. And I'd like for you to address that concern.
Yes, sure. Yes, Your Honor. Well, I'll start with what is undisputed, which is every fact that I'm listing here today is undisputed. There's no dispute about the facts that Bridgestone is relying on, and what I'm going to focus on will include those. One of those, well, there's two facts. One is that Bridgestone does vent hole drilling on every mold that passes through that Geisen machine, the blasting machine. The second undisputed fact is that that is the exact task that Mr. Lowe was doing at the time of the accident. And he was in the process.
I think my first question was the work that Mr. Lowe was doing interchangeable exactly with the work that regular Bridgestone employees were doing? I'd like you to answer that yes or no, and then you can explain.
This task, yes, not everything he did. And that is where you have two different standards, I believe, as you look at the two different tests. The regular business test does not require it to be exactly the same and interchangeable. And you can look at prior cases, I believe the Randolph case is a good example, where there are tasks performed where this rule has been applied, where they found the appellate courts in Tennessee found the work to be part of the regular business of the company when it was a type of maintenance or repair work that was not exactly what the principal contractor did. In that case, it was electromagnetic non-destructive testing that the company did not have the capacity to do. So there are things that Mr. Lowe would have been assigned within the mold repair shop, not this morning when the accident happened, but there were things that he would do that Bridgestone admits it would not do. They had a specialist in there to perform work that was above and beyond if that was required. On this morning, it wasn't required. And the second test, though, there isn't a great deal of case law on this, applying the second standard. One of them, I believe, is the Randolph case. There are a few others. And all of those cases, the common thread is that they focus on the specific work, the specific task that the worker was doing at that time, not what the worker might have been doing at some other time in some other context. But I'll focus back on the regular business prong because this is important here, and this case fits more within this exception, within this rule, I should say, than any other case that has been presented in any of the other reported decisions that we rely on in our brief. And the reason is that this could not be more fundamental to Bridgestone's business. You cannot build tires without curing them. You cannot cure them without having tire molds. Molds are comprised of different pieces, including the mold plate that Mr. Lowe was working on, that have to go into the curing press.
Mr. Sanders, if I could interrupt you just for a second, I do want to get at, I want to understand, I guess, your position on how important it is under this prong of the test that the work be like a central part of what the business does. So yeah, I take what you're arguing just now to mean that it was here, but as a general matter, when we're applying this test, how important is that? I mean, if you suppose it's a task that Bridgestone's employees do, but they don't do it very often, and it's really kind of incidental to the core of the company's business. So, if you had a delivery company that, the core of the business is delivering packages, but incidental to that, they occasionally have to provide maintenance on the delivery vehicles. Is that still the company's regular business? Or, does this test somehow require us to look at, like, what is the core of the, what's the reason why this company exists? What service is it providing? What products is it providing, et cetera?
Justice Campbell, I'll start with the end of what you just said. I think that this test does look at the broader business purpose or business function. But the standard does not require in the existing case law that this particular task be somehow the central part of it, or that it be some particular, function that happens every single day. And in fact, in most of these cases, you're talking about work that was done periodically during things like plant shutdowns, and it happened as late as every 18 months. The only cases where this didn't apply was where the court found, and this is one of these cases involved Bridgestone, another one involved another tire company, the Murray case, where there was no evidence that it had ever that it had ever occurred before, the type of cleaning and maintenance work that was at issue, or it had happened so sporadically that there wasn't any regular practice. So what this test looks at is it a part of the regular business of the company? And it looks broadly at what that business does. If you look at the Bristol Motor Speedway case, they were talking about food service, but the regular business test still applied because it was part of the broader production of putting on a race. In hospital cases, cleaning the medical equipment. In the case involving Kellogg, the Fayette Janitorial Services case, they're doing cleaning and sanitation services by a janitorial company.
So how many of those cases involve a legal determination at the appellate level based on summary judgment, as opposed to a case where it's been tried? There's been a full trial with evidence, and the appellate court is just reviewing the evidence that was put before the jury or the judge as the fact finder.
I'll frankly tell you, I don't know the answer to that question, Judge.
Don't you think that's important? Don't you think that's important? Because we have Bridgestone employees whose testimony is in the record talking about precisely that issue, and we have credibility determinations that are associated with how they phrase everything, how they describe everything. Don't you think that is an important perspective?
I think it can be, Your Honor, but I think that goes to the very purpose of summary judgment, and whether or not it's appropriate in any case depends on whether or not there are material facts in dispute. And there is no material dispute about the necessity of cleaning and maintaining and repairing tire molds and whether or not that is a regular part of Bridgestone's business. There simply isn't. Every additional fact that the plaintiffs have pointed to relevant to this issue is something additional that has not been required or even discussed in most cases by any court that has ever considered this standard. So if there were a material dispute that the plaintiffs could identify, that this court could identify, and I'll submit that neither of the lower courts identified any such fact in their opinions. So we don't have anywhere in this record, I will submit to you, any material disputed fact relevant to whether this is an important and regularly conducted part of Bridgestone's business within this plant, and has been for a period of decades, Your Honor. There is no witness, not even an expert that could be hired to give an opinion on this, that was willing to say that mold maintenance is not a regular part of Bridgestone's business. When
That's a very large umbrella, though. Mold maintenance. And part of what is disturbing me is that the components of that very large umbrella, it's very, very specific testimony that I don't have any expertise in. And that strikes me as the kind of thing that a jury normally assesses and makes a fact determination on.
I understand Your Honor's concern. I do, and I'm a fan of jury trials, and I understand the appeal of sending a case like this involving a tragedy to a jury, but what Your Honor is suggesting, I believe, would effectively eliminate the possibility of summary judgment, not just as to this defense, but as to any other where you just have to, where you basically say you go to the witnesses. There is no material dispute, and the plaintiffs have never identified one. They gloss over the second issue in their brief. The issue of vent hole drilling, that term appears one time in their brief. And the reason is that there is no dispute on this issue. There is no way for them to win on the merits on this issue. That result will not change at trial if the jury applies the law. And that is the purpose of summary judgment, Your Honors.
Well, let's talk about what's happened in this case, both at the trial court level and at the Court of Appeals level, with regard to the summary judgment standard. At the trial court level, despite the fact that there were cross motions, meaning that each party filed a motion for summary judgment, correct?
Yes, Your Honor.
On the statutory employer issue first.
Yes, Your Honor.
And the trial court denied both motions, correct? And found that there were genuine issues of material fact, which under our rules would preclude the grant of summary judgment, correct?
Yes, Your Honor, and I will, I'm sorry.
But the trial court, as I understand it, did not specifically identify what those genuine issues of material fact were. Is that correct?
That is correct, Your Honor.
And then we moved to the Court of Appeals. And again, right now I'm talking about the statutory employer issue. I'm not talking about the duty of care issue. Again, the Court of Appeals, in essence, simply said, yeah, there are genuine issues of material fact, but did not identify what those material issues were, correct?
That is correct, Your Honor.
So we have a record in which two courts have held that summary judgment was inappropriate for either side here, but they have not specified what issues were there, which in essence our rules require.
I believe that is absolutely correct, Your Honor. And I can understand in some cases that, trial judges often will deny summary judgment and say there are material facts. This case was appealed, and we are here today, I submit to Your Honor, because I don't think there is any legitimate basis in the record supporting those decisions. And I think that the inclination by trial judges and the Court of Appeals is when you have a mountain of evidence. And the other side has highlighted this in their brief as if to say, look at how many witnesses there are, look at how many documents there are, and there must be a factual dispute somewhere. But it is their burden, once we have made a properly supported motion, to come forth with specific facts that call into question what Bridgestone is relying on and that calls into question the application of these standards. And they've never done it. And the trial court and the Court of Appeals didn't fix that for them. This issue has been glossed over, and I submit that Bridgestone has not had its day before the judges yet where this issue has been properly addressed. And I understand that that is the default mentality in Tennessee and elsewhere to want a case like this to go in front of a jury and to say, we'll let them sort it out. But this is an extremely difficult set of circumstances. This will be a costly case. There are reasons that we have the summary judgment rules in place. And if this court identifies material facts that are in dispute based on evidence in the record, then that will be the basis for denying this motion and sending this case to the jury. But I submit to Your Honors that you're not going to find that in this record.
So your position would be, if we were to disagree with you on what as you claim, undisputed facts are, if we disagree with you on that, then the proper result would be to grant summary judgment to the plaintiffs as opposed to sending it back, right? I mean, you say there's no genuine issue of material fact, so if we happen to disagree with you as to what the legal conclusions are from those facts, you're saying the remedy would be grant the plaintiffs summary judgment.
If you're talking about the universe of facts that is material to these particular legal analyses, meaning these tests under the workers' compensation exclusivity rule and Blair, and if Your Honor looks at those and says—
I'm not talking about Blair right now. I'm not talking about duty of care. I'm talking about statutory employer only.
Okay, and I think my answer would be the same on both, which is that if Your Honors look at the facts and you find that there are no disputes and we're just wrong on the analysis, then yes, we would lose on this issue and this case would go before the jury without this defense intact. I submit that there's not a basis for such a finding, but yes, Your Honor, that would be the result.
Mr. Sanders, I'd like to back up, I think, for a minute and think about the statutory employer provision from more of a first principles standpoint. Some of our early cases, like in the really from the 20s for the next 60 years or so, I think read principal contractor to mean an entity that is performing work for another entity pursuant to a contract, then has a subcontractor. over time, I think our precedents have applied the principal contractor, term more broadly to include an entity like Bridgestone that is performing work, but just, delegating some of that work to an independent contractor pursuant to a contractor. But the principal contractor, in other words, doesn't itself have a contract. So it is not itself performing work for another entity that it then, subcontracts to another entity. If you look at the dictionary definitions of, principal contractor, they seem to agree that a principal contractor is an entity that is performing work pursuant to a contract. And that would mean then that Bridgestone can't be a principal contractor for purposes of the statutory employer statute. I'm not sure if you're following me here, but I want to just, do you have a position on that? I mean, do you think our cases that have kind of broadened that to include an entity, I guess, like Bridgestone in this situation are correct? I assume yes, but I'd like to hear your, any argument you have on that.
Absolutely, yes, Your Honor. And I know what you're talking about, because the first factor, this doing work for an entity other than itself, is where this began. But you have to look at it in the context of what the legislature has done. The legislature has also broadened workers' compensation coverage to include companies other than the direct employer, and that was intended to expand the protection to workers. It's so that companies like Bridgestone hire responsible contractors that maintain coverage, that do what they're supposed to do in taking care of employees. And it saw fit to put within that scheme a limitation that says, okay, well, you get that benefit, you get that additional protection, but you can't sue them in tort. And that's what we have here. And so going to Lindsay, if what Your Honor is saying is what this court was inclined to do, it would eliminate this doctrine and Lindsay entirely. 3 of the 4 factors would no longer apply with respect to most of the types of companies where it has been applied for more than 2 decades.
Well, let me just probe that a little bit, because I'm not sure that simply catastrophizing the ramifications of what Justice Campbell is asking is really what is needed here. Lowe points out in their brief that your client is not doing the work of another, which, as Justice Campbell mentioned, is part of the definition of a term that is required for you to be a statutory employer.
That has been treated, my only response to that, Your Honor, is that has been treated as one of the 4 independent criteria that merits a conclusion that the company is a statutory employer. That's how we got here. Bridgestone has never claimed that it was doing work for a company other than itself. It sells tires. And so we are traveling on the law that was set forth in Lindsay and in Griffith, Fayette Janitorial Services, Randolph, Lambert, and half a dozen other cases where every single prior opinion by a district court in this state or the Court of Appeals in this state is entirely consistent with and supports Bridgestone's position. Every single one of them supports Bridgestone's position in this case. And so what Your Honors are suggesting would upend all of that case law. And I don't mean to suggest a catastrophe, but this case presents a clearer circumstance of the work being part of the regular business of the company than any of those other cases. And part of that is because this is so central to what Bridgestone does. It is part of the manufacturing process to keep these molds in surface. But it's also something that, unlike every other case, it doesn't happen during plant shutdowns. It doesn't happen every 12 months. It's not part of maintaining a piece of equipment that might need it periodically. It happens every single day. It starts with Bridgestone. They do a task, and then the same exact task in this instance was done by the contractor, Mr. Lowe.
Okay, Mr. Sanders, appreciate it. I know you were answering a question, but I think your time's up.
Thank you, Your Honors.
May it please the court. My name is Drew Salters of the Nashville Bar. It's a pleasure to be here before Your Honor today. My co-counsel Brent Keaton and I represent the surviving spouse and widow of Beau Lowe and his 2 minor children. Beau Lowe coached his girls in softball. He was active in his church, and he died a very premature death at the age of 36 years old in a preventable accident, an accident that was preventable by Bridgestone. And Bridgestone here is engaging in circular arguments, pitting and putting tension in the law between two well-worn, well-traveled paths of established Tennessee law, Lindsay on the statutory employer side and Blair v. Campbell on the premises, the exception to premises liability for the independent contractor on the other side, where that tension does not need to be. And in doing so, what they're forgetting, what's in between 50-6-108 and 50-6-113 is 50-6-112, where the legislature specifically said there can be a third-party action in a case like this. There can be a third-party action when the statutory, or what they consider to be the principal. If Bridgestone is a third party, there is a third-party action available for my clients against them. I think we need to start with control of the conduct of the work, and I'm going to focus on statutory employer first, as my colleague did. And with control of the conduct of the work, Bridgestone admits that they did not control the conduct of Beau Lowe. They admit that. But this comes up in their duty argument of trying to put us in a catch-22 of, well, if he had to follow our process, then there was control. So it needs to be addressed. In the direct employment situation, where the employer controls the worker, the employer tells the worker when to come to work, when they can leave work, when they can take a break, but more importantly, how to do their job while they're there. So the priority of the work, the tools to be used, the steps to be taken. Bridgestone admits in this case, it's an undisputed fact, that they did not have the control of the conduct of the work of Beau Lowe. They admit to that.
Do they admit that they did not in fact control his conduct, or do they admit that they could not control his conduct?
The right to control is what you're hitting on there, Judge, and what their argument is they admit in their response to my statement of undisputed material fact number 7. They say, yes, we could institute procedures, but we did not control the conduct of the worker. So but then they engage in the circular argument of saying, when it comes time, if you need to lift a mold, then we want you to use our process in doing so. And they say, that means that we had the right to control. And we are saying that they are conflating right to control they have the right to control the premises. It's their premises. They don't have the right to control the worker, and they admit that. So that's where the tension is coming in. Now, Judge
Mr. Salters, if I could interrupt you, sir, I'm speaking from the screen. The control factor is the second Lindsay factor. The third factor is the activity part of the regular business of the company? And as I understood Mr. Sanders' argument, he was attempting to travel primarily on the third prong of Lindsay, which making tires is the regular business of the company, and this task, which your client did for his employer, was part of that regular business of the company. Would you speak to the third prong, please, of Lindsay, and tell us why you disagree with Bridgestone's argument on prong number 3. And if you don't disagree, would you let us know whether you think we need to modify that holding in Lindsay or overrule that holding in Lindsay?
Yes, sir. The regular business test is not applicable to this case. These facts are in dispute. Lindsay tells us that that these facts are not only, these cases are hypersensitive to the specific facts of the particularized facts of this specific case. That's what Lindsay says. And under the regular business test, Judge, regular business is not applicable. Why? Because it's mold repair. Beau Lowe was a millwright. He was not, Bridgestone doesn't employ millwrights. Beau Lowe is a millwright. A millwright is a highly skilled tradesperson who specializes in the repair, assembly, and disassembly of heavy industrial machinery. Bridgestone doesn't have any millwrights. Bridgestone, their own corporate representative, Mark Browning, testified, we don't have millwrights. We don't train them to do mold repair. By definition, if a mold goes to the repair shop, it means it is beyond the capability of Bridgestone, even if it is just drilling vent holes. Yes, maybe Bridgestone drilled some vent holes, but they couldn't, to the amount necessary for this particular mold, their workers couldn't get it. So it had to come to the mold repair shop, and they admit this too. On page 43 of the principal brief before this court, Bridgestone actually says, they say, that Bridgestone had determined and Cumberland understood that this mold was beyond the routine cleaning work that Bridgestone was able to do. That's why this mold went to mold repair. So if we follow Bridgestone's logic, Judge, under Lindsay, what that means is that any industry that has a repair element to it, it's about all of them, then that would be subsumed into the core business.
So how would you articulate, in answer to the question, what is the disputed fact or facts that prevents summary judgment? How would you frame that?
Judge, all of these are disputed facts.
Well, that's
who's-
not.
I understand.
I don't want arm waving. I want you to frame it for me. How would you articulate the facts that are in dispute?
Well, under regular business, the case law tells us essentially this. The fact is, if your business doesn't run without this key employee, then it's part of the regular business. There's an issue of disputed fact. Mark Browning testified that Bridgestone had 800 molds in reserve. So if a mold goes down, they can put another mold in. There was not a sense of urgency in this. And so in terms of regular business, the necessity of this particular worker, the integralness to the business, that's a disputed fact. The level of control that Bridgestone claims that they have or didn't have is a disputed fact. The process, all of these things. I know that I'll try to stay away from all, but there are numerous facts in dispute. Judge, we've taken 13 depositions in this case.
But you moved for summary, the plaintiff moved for summary judgment as well in this case, correct?
We did.
Okay, and as a part of the Rule 56 summary judgment process, there is a requirement that a party opposing summary judgment file a statement of what they allege are the disputed facts, correct? Okay. What statement was filed in the trial court on behalf of the plaintiff outlining the disputed facts? What were identified as disputed facts on the statutory employer issue? I'm not talking about the duty issue now.
The contract between Bridgestone and Cumberland, what was contained in that contract, the specific where he got his orders from, who assigned him work, what he was doing on the morning of. My colleague says that, he was just doing vent hole drilling. There's nothing in the record that says that's all that he was doing. When these molds, and this is going to be one of the disputed facts, obviously, was he just doing vent hole drilling, or was he doing more than that?
Well, but I want to confine it to what was put in the statement of disputed facts that was before the trial court.
There was 107 of them, Judge.
Okay.
I mean, it's lengthy. And I know that statement, and that was not by design, by trying to overwhelm anyone. It's just that when you litigate a case for 5 years and you take 13 depositions, even when you come to being as succinct as you possibly can be, there are just so many facts that are in dispute in these particularized specific areas.
Mr. Salters, I'd like to ask you the same. I'd like to ask you the same question I asked opposing counsel about, our cases that have expanded the definition of principal contractor to include an entity that is not performing work for another pursuant to a contract. Do you think those cases were correctly decided, or do you think we should return to a definition of principal contractor that really kind of hews more to the dictionary definition of that term, which would require that a principal contractor is performing work for another pursuant to a contract?
That's the way it originated.
I'm sorry.
That's the way it originated. And just to obviously, businesses and industries have evolved since 1919 when the workers' compensation law came out, and I think that we need to. Let me say this, Judge, in answer to that question. My response is this. Exclusive remedy is in 5608 in the early part of the statute, yes, and that just is the simple concept of workers' comp is your exclusive remedy. You can't sue your own employer in tort. The principal contractor exception, that was the public policy of trying to cover workers because it's devastating economically to a worker who's living paycheck to paycheck to get hurt on the job. So we want to try to find coverage for them. So coverage goes up the line to the general contractor. We normally see this in a construction type situation. When an uninsured subs employee is injured, coverage goes up the line until we find coverage because we want to cover that employee. But this is, but what Bridgestone is doing here is that they are using that as a shield, as a liability shield, as opposed to what the legislative intent was to try to find coverage. And they're ignoring 56112 that allows for third-party actions. I believe the singular issue before this court is should the entity who is in control of the instrumentality that causes the harm be given a liability shield, because that is what Bridgestone is asking you for.
Well, the statute expressly gives statutory employers that shield. That's a policy decision by the legislature.
That's right.
Not by us. What Justice Campbell is talking about is the case law that includes, under the term principal contractor in the statute, includes an entity who's not really a contractor. They're just hiring a contractor to do their work.
Right.
And so I think that is what Justice Campbell is speaking to.
And I think that the cases are varied under the specific facts of those particular cases. My colleague is relying on Griffith v. Jellicoe. In Griffith v. Jellicoe, Griffith was an employee of Aramark. Aramark had a specific contract with Jellicoe to contract out to Aramark to keep their biomedical equipment updated. It was software updates to biomedical equipment. And in that case, and the contract between those two parties indicated that. In our case, with Mr. Lowe, the contract that Bridgestone wrote between Bridgestone and Cumberland said, Cumberland, your employees are your employees. We don't cover them. You hire them, you train them, you supervise them. They're not our employees. Here's what that means, though, in answer to your question. So he's truly the employee of an independent contractor, and you're right. Bridgestone's not doing work for another. They're building tires for themselves. That's why we say, under the statutory employer test, Bridgestone should not be given the liability shield under statutory employer.
But the cases have said, well, in this kind of situation, Bridgestone was acting as its own general contractor. That's
right.
The reasoning that has typically been used. I'd like you to address that.
So Bridgestone is acting as a general contractor in the sense of, okay, we don't have the expertise to do mold repair, so we're going to hire Cumberland to do mold repair. And Cumberland, you are a separate entity. You're an independent contractor. We don't cover your employees. There's the answer. They're not Bridgestone cannot be considered a statutory employer. I would call it the proof is in the pudding test, Judge. If Beau Lowe had been injured with, say, something, your garden variety comp injury that he would recover from, say a cervical strain, and Cumberland had somehow allowed their insurance to lapse inadvertently such that they didn't have coverage, Bridgestone would be taking the inverse position now. Well, he's the employee of an independent contractor. We don't cover him. We don't have any responsibility to cover workers' comp benefits because he's the employee of an independent contractor. He's not our employee.
Let me, I do want to just clarify kind of your response to the question. So so what you're saying is that, what I understand you to be saying is that Bridgestone is not a statutory employer.
Correct.
Because it is not performing work for another.
Correct.
So, I mean, I think that going that path, I think would require us to abrogate precedents that have expanded the principal contractor definition.
Well,
are you asking us to do that?
No, Your Honor.
Do we need to do that to rule? I mean, I know you have arguments as to why these other factors are not met here, but you're not asking us to do that.
I'm not asking for the court to, I'm asking the court to follow Lindsay. Lindsay says that the principal cannot be considered the statutory employer if, when the worker that is injured is the one who is who has different expertise in a specialized industry that the principal does not have. I'm just asking the court to follow Lindsay. Lindsay breaks our way.
What does the record?
Let me.
Go ahead, Justice Tarwater.
All right, thanks, Justice Campbell. Let me go a little further on that issue. Okay, in Lindsay, the Lindsay test, the third prong of the Lindsay test, is whether the subcontractor's employees, whether their work is part of the regular business of the company.
Right.
Bridgestone takes the position that the Cumberland employees are doing part of the regular business of Bridgestone, and that this mold cleaning, and whether it's done by Millwright or whoever it's done by, is part of their regular business. Tell me what the undisputed or the disputed facts are about whether the Cumberland employees were engaged in the regular business of Bridgestone. What are the disputed facts about that?
Well, Judge, that's why we were proactive, knowing that they were raising workers' comp exclusivity. That's why I filed a motion for partial summary judgment on that, saying there are not facts in dispute regarding the fact that Beau Lowe was the employee of a truly independent contractor that was not controlled by Bridgestone. They couldn't tell him what to do. They didn't tell him what to do. With Beau, when a mold was damaged, whether it was dinged up, scratched up, needed to be resurfaced, clogged with rubber, whatever the case was, the instruction was simply, here's a mold that is unusable. Put it back in usable condition. We're not going to tell you how.
All right, so I'm sorry. Go ahead and finish your answer. I apologize.
Yes, sir. We're not going to tell you how to do it. We're not going to tell you what tools to use. Just fix it. That's the issue for, and the reason that this is not part of the regular business, Judge, to answer your question, is that Bridgestone functions just fine with it. Mold repair is not integral to their core business. They build tires. Mold repair is simply a repair element, and if mold repair, Mark Browning testified that if mold repair were to go defunct as an industry, Bridgestone would continue making tires. They have 800 molds in reserve, unlike Griffith v. Jellicoe, where the employee in Griffith, when he was injured and was going to be out of work for a number of weeks, Aramark had to give Jellicoe Hospital a replacement employee so that their hospital would run, because they couldn't run the hospital without him, without the independent contractor. So in my mind, it's like in the distinguishing factor between the Kellogg case and these cases that involve a plant shutdown, in those cases, what you see is you have independent contractor employees coming alongside the employees of the business that hired them, doing the exact same type of work. In our case, issues of fact are in dispute regarding this issue of the same type of work, and he wasn't. He was a millwright doing what only millwrights can do, that their own corporate representative testified, we don't do that. We don't do that in our plant.
All right, so here's what I think I heard you say, and I just want to make sure that I'm clear on this. At first, I thought I heard you say there are no material facts in dispute. It's just the interpretation of those facts. You believe the undisputed material facts indicate that Cumberland's employees were not engaged in the business of Firestone. Mr. Sanders, on the other hand, says the undisputed material facts show that Cumberland's employees were engaged in the regular course of business for Firestone. So, and this is what Justice Bivens asked you, Chief Justice Bivens asked you about earlier. Are there disputed facts or not? And if they're not, then we can decide this case either for you or for Bridgestone, correct?
Yes, sir. From the plaintiff's perspective, there are not facts in dispute as to this issue for regular business. This is,
Okay.
Mold repair is not regular business. That's not the regular business. And if you look at all of the case law, it comes down to that issue of, is this the business run without this or not? I mean, certainly with the amount of testimony that has occurred in this case, there are, well, Bridgestone certainly believes that there posits that there are material facts in dispute.
Well, I find it surprising to hear you say that, because your brief emphasized, well, Lindsay talks about this as a very fact-specific inquiry. Are you changing your position? Did I misunderstand your position? Tell me.
Well, maybe I misspoke, Judge. I mean, I'm not departing from my brief.
I'm not asking if you, I just want to understand, because
From the
going
plaintiff's
into this, I
perspective,
understood it differently.
we filed a motion for partial summary judgment on the basis that that when you look at these facts, clearly Beau Lowe was the employee of Cumberland Machine, and he was the employee of an independent contractor. Okay.
Well, help me understand the procedural posture of this. I'm genuinely not remembering. Are we reviewing the denial of the cross motions for summary judgment?
No, ma'am.
Or we're just reviewing the denial of the defendant's motion for summary judgment? So, if you're saying now that there's no facts in dispute, then to Justice Tarwater's point, we just look at what's in there and see how we interpret it. But that wasn't how I read your brief, and I just want to understand.
I'm not departing from my brief, Judge. Maybe I got confused. But when I followed Chief Justice Bivens' question to my colleague a little while ago, when he was asking about those same things, the cross motions, right, that's what I was referring to. That's what I meant to refer to. And if I misspoke, I apologize, Judge. My position in this case, our position in this case, is that clearly under the case law, Beau Lowe is working for an independent contractor. It'd be no different than that Cumberland has a shop, not on Bridgestone's premises, but next door, and they ask him, we've got a 2,200-pound mold. We don't want to pack it up and ship it. Can you come over here to fix it? But we're going to give you the rigging and the process with which to do it. He's an independent contractor working for something else.
Let me ask you the same question I asked your opposing counsel. Is the work that Mr. Lowe was doing interchangeable with the work, and I'm talking about the work that was being done at the time of the accident, is it interchangeable with what regular Bridgestone employees do? And if not, I want specific facts that speak to that.
It is not interchangeable, Judge. The mold repair, as Bridgestone stated in their brief on page 43, if by definition, if a mold goes to the mold repair shop, and by the way, Lindsay tells us to look at scale and scope. Beau Lowe was one of only 3 workers out of 1,300 in mold repair. If he's so much a part of their regular business, then why does his position encompass only 0.0023% of the workers in that plant?
I'm not hearing facts that go to specifically the kind of work.
The kind of work, it was resurfacing molds. Bridgestone employees don't do that. Minor mold repair, dings in the
Well,
molds.
is that what he was doing at the time of the accident?
We
Do
submit that
know?
he was doing anything needed to put the mold back into usable condition for tire
Oi,
manufacturing.
Oi, don't say all and everything and that sort of thing. I want specific facts. What was he doing specifically that day that was really not interchangeable with what regular Bridgestone employees do?
Doing mold repair, which is different from mold.
But how is it
Using-
different? I think I'm struggling with the same thing as Justice
Using,
Kirby.
using the tools that millwrights use to resurface a mold, to get dings and scratches out of a mold. Bridgestone employees don't do that.
But was he doing that on
The
the morning
record-
of the accident? What does the record indicate about
I don't
that?
know
about
that the
exactly
record-
what he was doing?
That is in his regular job. I don't know that the record I don't know that the record speaks to that, Judge.
So you've taken how many depositions and you've not specifically identified the specific acts he was doing at the time of the accident?
We have identified it in terms of he was doing the vent hole drilling because it was so clogged with rubber that it was beyond Bridgestone employees' capabilities to do. And he was also doing any other repair work that was needed. Judge, I don't know that anybody knows other than Mr. Lowe, who's not here to tell us, because nobody else saw that mold. It came to him and him alone to repair.
All right, so what I hear you saying is that he was doing mold drilling, which Bridgestone employees
That's
do,
right.
but it was at a level that the regular Bridgestone employees could not handle, and that's why that type of drilling was sent to the mold repair shop.
That's correct.
Okay.
That's correct.
Thank you.
And Judge, I've got to address duty briefly, and I only have a couple of minutes. The duty issue here, here's where an example would come in helpful, I believe. If Bridgestone were to hire, I've been to Bridgestone, the ceilings in their plant are very high. They're some 30 feet high. If they were to call, if they had lights go out in their ceiling panels, they call an electrician to come fix it. The electrician comes and they say, there's the problem, fix it. And that's all that they do, then Blair v. Campbell applies. We're not asking the court to overturn Blair v. Campbell. However, when the electrician gets there, Bridgestone says, we don't allow ladders in our plant because we've had incidents with ladders. Ladders are dangerous. So we're going to provide you with a scissors lift for you to access your work. And they put that worker on a scissors lift to access that work to make the repair. Giving him a scissors lift doesn't make that worker a Bridgestone employee. And Bridgestone couldn't take the position at that point of, well, you know what, light is integral to our work. We want to make sure that we need to have light to run our plant. Therefore, under the regular business test, we get statutory immunity. And in the process of that worker accessing that ceiling, the lift fails, just like the rigging failed in our case. And Bridgestone admits, by the way, that it was a rigging failure. Technical Record, Volume 5, page 568, their statement to my statement of undisputed material fact number 47. It was a rigging failure. If that lift fails and the worker falls to his death, then Blair v. Campbell has no application. We are not asking for this court to overturn Blair v. Campbell or to further restrict it or that there is any greater duty owed. All we're saying is that Blair v. Campbell does not have application because Bridgestone assumed a duty when they gave rigging, and they assumed a duty when they imposed a process that required my worker to have to suspend a load 6 feet in the air, which was a known TOSHA violation. They exposed him to an unreasonable risk of harm, and that is the definition of duty. So a duty has to be found. It looks like my time is up. I'm happy to answer any further questions.
Thank you, Mr. Salters.
Thank you, Judge.
Mr. Sanders, you tell us what the record shows with regard to exactly what Mr. Lowe was doing at the time of the accident.
Your Honor, this is on page 7 of our brief. There are 2 Cumberland witnesses who were deposed by opposing counsel who both said the exact same thing. Bridgestone's investigation concluded the exact same thing because the task came from Bridgestone to the old repair shop. So you have 3 different witnesses, Mark Browning and 2 Cumberland employees, who all said that Beau Lowe was drilling out vent holes in a mold plate when this accident happened. That's as cut and dried as it can possibly get, and that's why there is no contest on this issue in their brief, and there's no way to contest it in this argument.
If this was something that Bridgestone employees do in the regular business, then why didn't Bridgestone employees make this repair?
Your Honor, that's exactly where I was going next, which is this, we do not dispute, we've never disputed that this level of grit or dirt or whatever was in these vent holes went above and beyond what would happen in the normal sequence of passing through the Bridgestone cleaning stations, including the manual station. And so when the work was more extensive, or if there was some other kind of defect, that's when they sent it to the mold repair shop for Cumberland to take more time to do the task. It doesn't change the nature of the task. And the test that this court adopted is whether it's the same type of work. It doesn't even have to be the exact same task, and yet here it is the same task, it's just more of it. Chief Justice Bivens, you asked about statements of undisputed fact, and there was a reference to 107 of them. I want to remind the court that they also moved for summary judgment with respect to Bridgestone's comparative fault defense. And that motion speaks for itself. They covered the entire case. The point was not to win it. They loaded up the record, just as they've done at every stage, with a bunch of things that have nothing to do with the Bridgestone defenses that we believe resolve this case, that they've been aware of as they've acknowledged since the day it was filed. They talk about whether the bolts were properly inserted, who was responsible for the rigging, who did what in inspecting these things. They want to make this about who was at fault. But if the statutory defense, the exclusivity defense applies here, you don't reach those issues. And to respond to Justice Kirby and Justice Campbell about whether this scheme should be redone, I'll remind the court this didn't just start with Lindsay. I mean, I understand that it has evolved since 1918 or whatever, but it also dates back to Stratford. It's a 1985 case, and the court has built on this over my entire lifetime because that's the year I was born. And so this goes back. There are businesses in this state that have been relying on this scheme, that have their contracts that are based on this scheme in part because it does 2 things. Again, it makes them secondarily liable for workers' compensation coverage. Principal contractors, whether it be a Bridgestone or a home builder, they are secondarily liable if they hire subcontractors or independent contractors that don't have appropriate insurance, that don't have appropriate financial backing. And that's not what happened here. And if your honors look at the contract, it's in record volume 10 in the last 5 pages. This contract made as sure as Bridgestone could be that Cumberland took care of these things. It required workers' compensation insurance. It required coverage. When plaintiffs talk about all these things that Bridgestone might do if Mr. Lowe was not covered, they're leaving that out, and they're also conflating the difference between 2 analyses. There's an analysis that addresses whether an employee is an independent contractor or whether a worker is an independent contractor or an employee. And then there's a separate analysis, which is whether a company is a statutory employer. And there's some overlap in those tests. They look at different things, but they have entirely different purposes. And we are not talking in this case about the borrowed servant doctrine or the difference between an employee, and an independent contractor. If this court applies the law as it has existed for decades, then the result in this case is clear. You invited opposing counsel to try to identify material disputed facts on either test. I've covered the first, so I'll go back to the regular business test. There is no case and no standard that suggests that this must be a key employee. You don't look at the percentages of the factory or the percentages of the workers. The question is simply whether it is a regular part of the business.
Can I ask you on the regular part of the business question? When Bridgestone employees are doing the hole drilling that you were describing, were they using the same apparatus that Mr. Lowe was using?
They were using the same drilling equipment.
Were they using the same, I mean, the apparatus that ended up having the mold fall on Mr. Lowe, were the regular Bridgestone employees using that?
Similar equipment, but in a different area, not the exact same equipment, and there were differences in the setup. Cumberland ran its own shop, and there were differences in how they choose to utilize that equipment, but they both involve an overhead crane. If you're going to drill the vent holes out, you have to flip a mold plate.
But it's a different apparatus.
It is a different, it's right next door, but there is a different overhead crane that's, you know, it's not on the record, so I won't try to speculate about the distance, but it's not far apart, but it is a different crane. One of them is right next to this Geisen machine. It's a large contraption. It comes through, comes out hot. They do the work, and then if it needs to be transferred for additional cleaning work, which is what happened here, all again within the mold repair area, it goes to the mold repair shop next door. It is the same task done with different lifting apparatus, if that answers your question, and different drills. They don't carry the drills from one spot to the other, but they're still using a drill bit because there's no other way. I think it's a 1/16 or 1/18" drill bit because these are tiny little holes. So it's the same equipment, same process, same exact task. It is most certainly the same type of work that Bridgestone was doing. And again, I'll just reiterate, every factor that they've tried to add, every fact that opposing counsel tried to identify in the briefs and here before your honors is something in addition to what courts have considered to date. It is an extra factor. What they are trying to do is gut these defenses so that they have no application going forward for anyone.
All right. Thank you, Mr. Sanders. Your time is up. We appreciate it.
Chief Justice Bivens, may I ask one question of Mr. Sanders before he leaves?
Okay.
Thank you. The Phillips case, 1991 case out of the Middle District, similar facts, not exact, but similar facts. Bridgestone is the defendant in that case. Seems to cut against your position. While I understand that a United States District Court case is not controlling precedent, what would you say about Phillips and what attention we should pay to it, if any?
What I will say about Phillips is that it was a decision by Judge Nixon, I believe. That case, it did involve a similar fact pattern, but the record before that court was not sufficient to render any conclusions about the issues that Bridgestone is primarily traveling on here. That entire opinion focused on the right to control and a separate legal doctrine, the borrowed servant doctrine, which applies a completely different standard. And there is some reference to some of the factors that happened here, but there is no analysis as to the regular business test. There is no analysis as to whether it was the same type of work being performed by Bridgestone. And I don't know why counsel 35 years ago did not raise those arguments. I don't believe that they had been fleshed out by this court quite as clearly. For whatever reason, they weren't part of the record. And so that opinion with respect to the issue of control, I think would have some instructive value, but for the fact that the plaintiffs in this case are pursuing a totally different type of claims. And I'll let our briefs speak on that and what they're trying to do here with their premises liability claim.
Thank you, Mr. Sanders.
Thank you, Your Honors.
All right, counsel, thank you so much for your good arguments here today. We also, again, very much appreciate you agreeing to participate in our Scales program here today. And with that, we will now unleash the students on you to allow you to answer their questions. So we appreciate it very much. Thanks everyone for being here. Mr. Hibner, please adjourn court.
All rise.